you have to act when you are making a decision for the company that is actually in the company, in the LLC's best interest and not the interest of yourself solely. So as I stated, if you are making a decision with the best interest of the LLC at heart, and that decision turns out in hindsight not to be the best decision, but you can certainly give reasons and say, okay, I made this decision. If somebody questions you on it or litigates, another member sues you and says that you breached your fiduciary duty of care to the LLC, and you say, okay, well, this is why I made that decision. And as long as that decision doesn't rise to the standard of negligence or reckless disregard, then there's not going to be any liability. But clearly, if there is an indication that the person made that decision for their own self-interest, that's a problem. If they made that decision because they're trying to protect themselves because they didn't disclose a possible conflict, that's a problem. If they just make the decision and say, well, I understand that I owe the duty to the LLC, however, the business is going other, or I have other business interests that are more important, and I just don't care, and I make a decision, and obviously I haven't done any analysis in regard to that decision, then that could rise to the bar of negligence. So as long as a member stays clear of those things and they have performed their obligation for a fiduciary duty to the LLC as a whole. If they don't, then they've breached that duty.